Welcome to Run Tell This and BET present Justice for George Floyd, our special coverage of the murder trial of former Minneapolis officer Derek Chauvin. I'm Mara Schiavocampo, joined by Wesley, Lowery, and Keith Reed. We are the co-hosts of the podcast Run Tell This. If you're not familiar with us, please check us out wherever you listen to your podcast, Run Tell This, or on social media at RunTellThis_.
We're going to be joined today by trial lawyer and former circuit court judge Billy Murphy. He's tried several police brutality cases and famously represented the family of Freddie Gray in Baltimore. Billy, welcome to the conversation.
Thank you very much. It's good to be here.
It's great to have you. We want to jump right into this conversation. The defense has been putting on their case. In the courtroom and what you've been seeing over the last couple of days, what is the defense's key argument and what's your opinion of it?
The key argument is that the police officers did not cause Mr. Floyd's death. And I think that's a bogus argument and easily disproved. The prosecutor, Jerry Blackwell, surgically dismembered the former chief medical examiner for the state of Maryland, with whom I'm familiar because I've cross-examined him as well. And he did far better in his cross-examination than I did in any of my cross-examinations. He was that good. It was a masterful performance. And the highlight of that cross-examination was when he forced Dr. Fowler to admit, and it was opportunistic. I don't think it was planned. It was that brilliant. He forced him to admit that after Mr. Floyd suffered from cardiac arrest and before he died, that the officers should have intervened to try to resuscitate him because Jerry Blackwell established before that line of questioning that resuscitation was possible.
Cardiac arrest is not absolutely irreversible and not synonymous with a person always passing away.
Are you suggesting that though Mr. Floyd may have been in cardiac arrest, there was a time when he may have been revived because he wasn't dead yet?
Immediate medical attention for a person who's gone into cardiac arrest may well reverse that process, yes.
Do you feel that Mr. Floyd should have been given immediate emergency attention to try to reverse the cardiac arrest?
As a physician, I would agree.
You just said, brilliance. They dismembered their witness. You use terms like that. And as a layperson, someone who has no legal training watching, I felt like the prosecution was really destroying these witnesses. So I texted a lawyer and I said, hey, I don't have a lot of context for this. Am I interpreting it correctly? And they responded with a GIF of somebody getting knocked out in a boxing ring. So is it your analysis that the prosecution is crushing it the way that it appears to a lot of lay people?
Oh, absolutely. And in so many different ways. Jerry Blackwell gave a clinic on cross-examination, step-by-step demolition, systematic destruction.
Did you analyze where Mr. Chauvin's knees were relative to the positioning of Mr. Floyd's body in that first 5 minutes?
I did review the positioning, yes.
And so Mr. Floyd then is sandwiched in a way between Mr. Chauvin on top and the asphalt pavement beneath it, right?
Yes, if you...
It's a yes or no question.
Yes.
When the defense's use of force expert was on the stand, and the prosecutor made the defense's use of force expert kind of walk back a statement that he made. And he said, a normal person or a reasonable person would have just been resting comfortably under the knee of Derek Chauvin. And
that was hard. That was a hard moment, right?
It was a hard moment, but it was a weird moment because it was almost as if you could almost see the prosecutor's eyes light up.
Up to this point and beyond this point, the defendant did not alter the level of force that he was using on Mr. Floyd, did he?
No.
Even though Mr. Floyd by this point had become, as you put, compliant. Fair?
More compliant, yes.
Well, what part of this is not compliant?
So I see his arm position in the picture that's posted.
Right.
that, a compliant person would have both their hands in the small of their back and just be resting comfortably versus like he's still moving around
Did you say resting comfortably?
or laying comfortably.
Resting comfortably on the pavement.
Yes.
At this point in time, when he's attempting to breathe by shoving his shoulder into the pavement.
I was describing what the signs of a perfectly compliant person would be.
Do you get the impression that the defense has not prepared these witnesses for cross-examination?
The defense has hurriedly prepared this case. And it's evident throughout the trial. He got off to a very slow start during the state's case. He did not appear to have a theme that he developed in cross-examination. He was not opportunistic. Then he kind of gave up after a while and didn't do much cross-examination at all. And then he resumed cross-examination when he felt more comfortable, meaning more prepared for it. And then his witnesses, who are difficult to prepare, you have to put a lot of time in preparing witnesses, whether they're lay witnesses or defense witnesses. It didn't look like he put the time in to close all of the holes so that the mouse couldn't get away from the cat. And so there were many, many instances where it looked like he was getting unexpected answers to questions that he should have been very thorough about. When you're on a national stage and everybody wants to see what you got, it's inexcusable to be this poorly prepared.
We've talked a bunch about the prosecution's case and the defense's case. And I've been reading a bit in the time between the trial, looking back a lot at the Rodney King trial and just thinking about how that played out and how things went. And I had stumbled across a first-person piece written by one of the jurors in that trial of those officers, which ultimately acquitted the officers in that beating, although there was later a federal civil finding. And what was interesting was this woman was describing at the time how a juror, how she thought the prosecution was overly emotional, that they were exaggerated, that they were saying things that were objectively true about this unacceptable use of force and about the history but how that had, for whatever reason, rubbed her the wrong way. In a case where it does seem to the outside observer that the prosecution's winning at every juncture here, is there any risk to blowback? Is there a risk to spiking the football and it seeming too obvious, and if it turns off one juror, it makes them feel, the cops aren't getting a fair shake here. What is the risk in terms of managing a jury in a case where you have such compelling video evidence and also where it seems like a lot of things are going your way?
Well, with the caveat that it only takes one juror to say, I'm not convinced that the prosecution proved the case beyond a reasonable doubt. I think that the prosecution has handled this case from an emotional level in a level-headed, reasonable way. I think Jerry's strategy was to avoid emotion and to stick to the facts, just the facts, nothing but the facts. And I think that's worked. I think that the defense, on the other hand, is falling into the trap of emulating the lack of animation in the prosecution's case by coming across in the same way. That's a trap. He fell into it. I think the defense should be much more emphatic when it is making a point. Not that it has made many points, but you've got to make sure that the jury doesn't forget the points that you make. And so I think that the defense has not shown that oomph, that fire. It doesn't have to be a lot of fire, but it has to be enough so that you can feel it. It hasn't shown that fire. It hasn't shown its belief in its client's cause. It hasn't shown the kinds of things that you would expect from a great defense lawyer.
Billy, what are the points from what we know of what the defense's argument is, the points they're trying to drive home? What are the points you would be more fiery about? If you switched roles, you were now defending the police officer, what would you be leaning into here to try to get Chauvin off?
Well, I would have chosen the same defense that they've chosen because, after all, there isn't much choice in this case. I would have chosen using the same kind of reasoning that the defense has employed, but I would have done it with more flair and more oomph because there is a lot there, except he got betrayed by his witnesses because, as you pointed out, there seemed to be a lack of preparation. And so there's no way in the world I would have let Dr. Fowler testify that they should have resuscitated or tried to resuscitate him, because that's an independent ground for conviction. That's part of what the prosecution's list of theories of conviction is. And so this list has been checked off. And when you have somebody, the eminence of a Dr. Fowler and the experience of a Dr. Fowler making that damaging admission, I don't know if I'd speak to him after he got off the witness stand if I were the defense. The penalties are high for each charge. The lower level offense is punishable by 10 years in jail. I think everybody could live with a 10-year sentence in this case.
Do you think that the public would be satisfied with a 10-year sentence and eligible for parole and, less than that?
Well, there would be elements, especially in our community, who would not be happy with a 10-year offense. And so I think you're going to see that the African Americans, if they are convinced that there's proof beyond a reasonable doubt, are going to argue in the jury room very strenuously for the top line offense. And I think that that's going to be an acceptable result. If it's a lower level of offense, he's going to go to jail for the maximum. I don't see this judge cutting him any slack, especially under the glare, the national attention that he's getting in this case, and the possible consequences of a light sentence on the community at large. There will certainly be an outburst. I'm not condoning it, but I'm predicting it. So I think that you're going to find a conviction on one of the top line charges in this case, because the evidence is that overwhelming. And the judge will carefully go over in his jury instructions the elements of each offense.
Before we let you go, we saw another officer just outside Minneapolis in a suburb called Brooklyn Center, who shot and killed a young man, 20 years old, by the name of Dante Wright a couple of days ago. She was charged with second-degree manslaughter. Any thoughts on that case? Do you have an opinion on the charges? Should they have been more serious, or do you think it's appropriate?
I'm literally bursting with frustration about what the commentators have not discussed about that case. Let's talk about the use of the firearm, and then we talk about the use of the taser. You are not supposed to approach a car with your firearm drawn. There's no reason for that. You're not supposed to have your firearm drawn, in particular, while there appears to be an orderly arrest. Even worse, you're not supposed to have your finger on the trigger. It is supposed to be outside of the trigger box in parallel with the barrel of the gun, because it is too easy when you have your finger on the trigger to accidentally shoot somebody in the spur of the moment, in a sudden shock in turn of events. And that appears to be what happened here. So she didn't follow her training about how to handle that firearm. And a lot of people have been shot because of that. Now let's look at the taser. The taser is supposed to be in her weak hand, not in her strong hand. Strong hand is the gun hand. I'm not buying her explanation that she thought she had a taser in her hand, except instead of a gun, because the taser would have been in this hand, not this hand. She knew she had a gun, and she said, oops, because she knew she should have had her finger on the trigger, and she should not have impulsively responded to what was going on by pulling the trigger. And so, yeah, I think manslaughter is the appropriate charge because it was a gross violation of her training. It was indifference to human life, and it was careless, grossly negligent.
Billy Murphy, trial attorney and former circuit court judge in the state of Maryland. Thank you for being here on Run Tell This.
It was my pleasure, and it was my pleasure to interact with such excellent journalists.
Columbia University professor in neuroscience, Dr. Carl Hart, joins us next. He's known for his research and his analysis of drug use. Dr. Hart, we're really excited to have you.
Thank you. I'm happy to be here.
Now, in your new book, you write about how the trope of the, quote, drug-crazed Negro is often used in cases like this. And so we wanted to start off by having you explain to us what that trope is, some of the history of it, and how it manifests in a case like this.
We saw it not only with George Floyd, we saw it with Laquan McDonald in Chicago, the 17-year-old kid who was shot 16 times. And they said he was on PCP. We saw it with Rodney King, although he wasn't on PCP, they said he was on PCP. We see the drug sort of narrative come up as a way to excuse bad police behavior. In Tulsa, Oklahoma, 2015, I believe, Terrence Crutcher was shot by Betty Jo Shelby, the cop, and they said, well, he had PCP in the system, therefore she was exonerated, she was acquitted. And so we see this throughout. I just have to say that over the summer, the prosecutors in the Derek Chauvin case, they reached out. I met with them because I wrote a piece in the New York Times saying that back in July, saying that we can expect to see the defense to use this defense. And sure enough, on cue, this is the defense that they're using. When I watched their medical examiner testify last week, he left an opening for that juror to say that, well, drugs were a contributing factor. In fact, that's what he said in his testimony. And he said, like, methamphetamine was a contributing factor and fentanyl was a contributing factor. They were not. That was just that, there's no scientific evidence to support that sort of notion. The level of methamphetamine that he had in his system was so low that it wouldn't change cardiovascular activity, and his fentanyl use, given that he was interacting with the folks when he tried to purchase something in the store, he interacted with the police appropriately. All of that suggested that he was tolerant to fentanyl-related effects. Otherwise, he would have been lethargic and sleepy. He was none of those things. He was appropriate. So this notion that those drugs contributed to his death, just not supported by the scientific evidence.
Almost every high-profile police killing of a Black man in memory, it's certainly in my lifetime, has had that same element of the drug-crazed Negro, right? Whether it's Rodney King, whether it's Mike Brown, whether it was even with Trayvon Martin. He was not killed by a police officer, but afterwards there was all this speculation about, he was high on marijuana, where I think most of us know just anecdotally people who are high on marijuana are the least aggressive people on the planet. But it's generally brought in as this way to explain why this excessive force is needed or why any force is needed because of this notion of this superhuman Black man on drugs. But in this case, it felt to me a little bit like they were playing yesterday's game, because the conversation about opioids has changed because so many white people have become addicted and have died as a result of opioid overdoses. So now we see this compassion, this understanding. They're not criminals, they're addicts. They're suffering from the disease of addiction. They need care and recovery. They don't need jail time. The whole conversation about drug use has now shifted.
I don't think the culture has changed. One of the things that people get ahistorical about, for example, people say with crack, we put people in prison and we had this one sort of way. That's just not true. We did exactly the same thing we're doing now. White people went to treatment, Black people went to jail. We had
But the way it's received by the jury, when they hear opioid addict, do you think they're hearing the same thing as PCP user 20, 30 years ago?
No, all they need to hear is that opioids cause overdose. Therefore, opioids cause George Floyd's overdose. That's a little different twist here. And the defense is playing that different twist. And he knows that the jury think fentanyl, immediate overdose. And that's what he's playing.
My perception was that it was such a potent drug that overdose is very probable, or certainly not unlikely. So what is the reality when it comes to fentanyl use?
So I tried to explain this in my book. The thing that we need to understand is that fentanyl is a potent opioid. When I say potent, all I mean is that the amount that's required to have an effect is small. It's very low. And that's all I mean. But when you take the drug as prescribed or doses that it's fine. It's so fine that we give fentanyl to children. We have lollipop formulation. So we have fentanyl in lollipops for children who have cancer or something of that nature. What we tell the country is like, oh, you take fentanyl, then you die. The only thing that where it becomes dangerous is when people think that they have one opioid like oxycodone or heroin, and in fact, they have fentanyl. And they take the same amount that they would have taken of heroin, and then you can have an overdose in that way.
As you watch this, not only are looking for what the prosecution is challenging around drug usage, but also around the language that's being allowed as George Floyd is being described, and some of the other science that's being allowed, specifically around excited delirium.
Excited delirium is a wastebastic term that can mean anything.
A what term?
Wastebasket, garbage terms, means nothing. That's what excited delirium means. And in psychiatry and medicine, it's not a thing. That's not a diagnosis. It's a pseudo-diagnosis. And the only people who use it are cops and lawyers, but not in medicine. It's not a real thing.
And Doctor, what do they use it to mean? Explain what they are suggesting is true.
So cops and lawyers use it to mean anything from somebody got excited and then they just died, to somebody got so excited that they developed superhuman strength, or somebody so excited that they are uncooperative. So it means all of these things, anything you want it to mean. That's why it's a wastebasket term that has no meaning in medicine. I told the prosecutors this past summer. They weren't really trying to hear that.
Dr. Carl Hart, thank you so much. Your book is Drug Use for Grownups. I found it to be fascinating, whether people agree with your arguments or not. It still challenges things that we all commonly believe to be true. And anything that challenges me, I enjoy tremendously. So thank you for that. And thank you for being here.
Thank you.
Thank you for watching our special coverage of the Chauvin murder trial. This is Run Tell This and BET Present Justice for George Floyd. Please continue to keep an eye on BET's social media channels for more coverage. And please check us out at Run Tell This _ on social media or wherever you get your podcasts. We are Run Tell This.